The present lecture is a continuing lecture of the previous video due to some unavoidable emergent and or emergency situation. We have to stop at the middle. So we have left in the previous lecture on capital account transactions. And lastly, we have discussed about the foreign direct investment. And also now we will go to the very penalties for contravention of the provisions of the Foreign Exchange Management Act. So, anyone who violates the very provisions or the related rules of the Foreign Exchange Management Act and those circulars and notifications issued regarding the Foreign Exchange Management Act, so the very penalties would be three times the amount involved in the violation in regards to the very transaction or arrest to lag whichever is higher. In the cases of continuing violation, the person can be fined an additional amount up to Rs 5,000 for each day the violation continues. And now we'll discuss the very applicability of the very provisions of the Act. So, which particular areas or persons to whom the very Act of Foreign Exchange Management Act of 1999 is applicable. So, in that regards, we found that the Act applies across all over India and to all citizens whether they reside in India or abroad, and to all Indian entities operating abroad, to all overseas companies owned by the non-resident Indians, if they own at least 60% of the shares of the company, the main office called the Enforcement Directorate is the very authority which governs the activities such as foreign exchange, foreign securities, export and import of goods and services, securities defined under the Public Debt Act, and also all forms of financial transactions like banking and insurance. So, in regards to that, the applicability we could discuss in two heads, that is authorized persons and the permitted activities. So, as regards to very applicability, the very authorized persons which are falling under category 1 of the Fema Act are commercial banks, state cooperative banks, urban cooperative banks, and the very permitted activities to those authorized persons under category 1 of Fema Act is all current and capital account transactions as per the Reserve Bank of India directives, And in regards to category 2, those authorized persons are included upgraded full-fledged money changers, commercial banks, regional rural banks, and also cooperative banks, and the very authorized and permitted activities to these authorized persons under category 2 of Fema Act is that all full-fledged money changers, approved activities and current account transactions not related to commerce. And in category 3, as per the provisions of Fema Act of 1999, all the select financial and other institutions are considered and falling under as authorized persons, and the permitted activities to them are transactions related to foreign exchange. And finally, category 4, where the Fema Act defined authorized persons as urban cooperative banks, Department of Post and Telegraph, and other financial institutions and their permitted activities as purchase and use and sale of foreign currency for personal and professional travel around. And now we'll discuss another important provision of the Fema Act, and that is regarding prohibited transactions. So, what are the very prohibited transactions under the Fema Act, and that we would like to discuss? So, those prohibited transactions which are falling under the Fema Act are lottery winnings. You cannot send money abroad if it comes from winning a lottery, and this very transaction is prohibited under the Fema Act of 1999. Also, those incomes coming from racing. So, in regards to that, money earned from activities like horse racing or riding cannot be sent out of the country. As regards to current transactions, and it is prohibited under the Fema Act of 1999. So also another prohibition is regarding buying lottery tickets. So you cannot send money abroad to buy lottery tickets, participate in football pools, and also you cannot put your money in casinos. So also you could not send your money abroad to purchase certain magazines which are banned in India. And also another important transaction of foreign exchange is relating to dividend remittance. So, in that regards, companies cannot send dividends abroad if they are required to balance their dividend payments according to the applicable rules. And finally, another activities which is prohibited regarding transaction of foreign exchange in regards to export, commissions. So, we would like to discuss the export commission under two heads. One is export commission for investment. Commissions paid on exports that are used for equity investment in Indian companies, joint ventures, or wholly owned subsidiaries abroad are completely prohibited under the Fema Act in relating to export commission for investment. And the second aspect of export commission is on rupees state credit routes. So commissions on exports under these routes are restricted. As an exception, up to 10% commission for exports of tea and tobacco is allowed. So, now we'll discuss those regulations and rules which are framed to properly execute and implement and to carry out the provisions of the Foreign Exchange Management Act of 1999. So, among those rules and regulations we could like to discuss the first one, Foreign Exchange Management, Export of Goods and Services regulations which were made in 2015, and the Foreign Exchange Management manner of receipt and payment regulations which was enacted in 2016, and also the Foreign Exchange Management Remittance of Assets Regulation of 2016, and also Foreign Exchange Management Deposit Regulation of 2016, and also in the year 2017, Foreign Exchange Management Transfer or issue of security by a person resident outside India regulation was enacted in 2017, and another piece of rules and regulations for proper execution and implementation of the Fema provisions was enacted in 2018, that is the Foreign Exchange Management Borrowing and Lending Regulation 2018. And so also Foreign Exchange Management Acquisition and Transfer of Immovable Property in India regulations of 2018, and also some other rules and regulations such as the Foreign Exchange Management Current Account Transaction Rule 2000, Foreign Exchange Management Permissible Capital Account Transaction Regulation 2000. So, also Foreign Exchange Management Possession and Retention of Foreign Currency Regulation 2000. So, these are some important regulations and rules enacted and framed to proper implementation, execution, and working out of the very provisions of Foreign Exchange Management Act of 1999, which in particular aimed at all illegal transactions in foreign currency and aims at foreign exchange reserve, and it also determines the very limits of foreign direct investment, and in consequence to that would like to discuss one of the most important provision, and that is the Foreign Contribution Regulation Act of 2010, and which was amended in 2020. So the Foreign Contribution Regulation Act of 2010, and the very applicability of this act was as provided under section 1 subsection 2. It applicability is to whole of India and citizens of India even outside India and associated branches and subsidiaries outside India of companies or entities or bodies or corporate registered or incorporated in India. So also those rules and guidelines which regulate the flow of foreign contribution to India as per the Foreign Contribution Regulation Act 2010. So also Foreign Contribution Regulation Rules of 2011, and as such, now the very question is that what is foreign contribution? So the very definition of foreign contribution is provided under section 2, subsection 1 and clause H. Foreign contribution as per the provisions of this section of the Foreign Contribution Regulation Act of 2010. It includes all kinds of donation, delivery or transfer made by any foreign source, as such of any article not being an article given to a person as a gift for his personal use. If the market value in India of such articles on the date of such gift is not more than such sum as may be specified from time to time by the central government by rules made by it in this we have. So, the very sum has been specified as at present and currently as it is rupees 25,000 of any article given as gift, and also of any currency whether Indian or foreign, and of any security as defined in clause H of the section 2 of the Securities Contracts Regulation Act of 1956, and which includes any foreign security as defined also in clause O of section 2 of the Foreign Exchange Management Act of 1999. And we found some explanations provided under the Foreign Contribution Regulation Act of 2010. So the very explanation In regards to the first one, or a donation, delivery, or transfer of any article, currency, or foreign security, referred to in this clause by any person who has received it from any foreign source, either directly or through one or more persons, shall also be deemed to be foreign contribution with the meaning of this clause. And as regarding explanation 2, in regards to clause S, the interest acquired on the foreign contribution deposited in any bank referred to in subsection 1 of section 17 of the Act, or any other income derived from the foreign contribution or interest thereon, shall also be deemed to be foreign contribution within the meaning of this clause. And finally, explanation 3, which provides any amount received by a person from any foreign source outside India by way of fee, including fees charged by an educational institution in India from foreign student, or towards cost in lieu of goods or services rendered by such person in the ordinary course of his business, trade, or commerce, whether within India or outside India, or any contribution received from an agent or a foreign source towards such fee or cost, shall be excluded from the definition of foreign contribution within the meaning of this clause. So, these are the important parent acts and those regulations and rules subsequently enacted in regard to the Foreign Exchange Management Act of 1999, and also regarding the Foreign Contribution Regulation Act of 2010. So, from the very initial foundation laid down in 1974 by enacting Foreign Exchange Regulation Act in regards to regulate and control foreign exchange reserve, and the very investment and expenditures, and relating to those expenditures and investment which are falling under current account transactions and capital account transactions. All the necessary provisions provided under the Foreign Exchange Management Act in regards to prohibition of certain transactions, and also the penalties for contravention of such prohibited transactions, and that we have discussed in relation to the Foreign Contribution Regulation Act of 2010, and which was consequently amended in 2020. And in connection to that also, we have discussed the Securities Contracts Regulation Act of 1956, and all these enactments and the continuing expanding activities in the corporate sector, so also in individual sector, in regards to the companies and all kinds of individuals and associations, firms dealing with foreign exchange, transaction, investment. The Parliament of India ultimately enacted another piece of legislation which is completely relates to most of the acts relating to either Foreign Exchange Management Act and all those financial irregularities, and as such the very act that was enacted in 2002, that is the prevention of Money Laundering Act of 2002, which we would like to discuss in another session in our lecture series on, in particularly relating to financial irregularities by individual citizens, by the non-resident Indians, and also by the corporate sector and the companies and firms, and that in particularly in relating to prevention of money laundering act of 2002, would like to discuss the issues relating to prevention of money laundering act in our next upcoming